Hi, welcome IFA friends. My name is Sarah Davies. I'm the General Counsel for IFA. And thank you so much for joining us today. We're happy to bring you today's IFA Government Relations webinar on the Corporate Transparency Act regarding beneficial ownership reporting and what you need to know about the new requirements that went into effect January 1st of this year. As you may know, the CTA was passed in 2021, now effective this year, although there is a bill pending in the Senate that would extend the deadlines. So on a later slide, there will be a QR code to sign up for Franchise Action Network so that you can stay current with developments with respect to that bill and what's going on with the CTA. On today's program, you'll hear from Beverly Odom with Wolters Kluwer, a provider of CTA compliance services. First, two announcements before we get started. The webinar today is being recorded. The recording and slide deck will be available on IFA's community site later today at community.franchise.org. That's community.franchise.org. And second, we'll take questions from the audience. Please feel free to enter them anytime during the program in the Q&A box on your Zoom screen. And to the extent questions are related to the slide that we are on, then we'll address them at that time. Otherwise, questions will be addressed at the end of the program. Just a bit of housekeeping. We, given the complexities of the CTA, certainly encourage you to seek guidance from your attorney regarding what entities need to do to comply specifically, given the number of exemptions that are available under CTA and as you'll see in the program, cumbersome language as to substantial control and affiliated entities. So we can't provide legal advice on this webinar. With that, I will kick it over to you, Beverly. Thanks.
Thank you, Sarah, and welcome everyone. And as Sarah said, my name is Beverly Odom. I am a transactional business consultant with CT Corporation. I live and work out of my home in Alpharetta, Georgia, and I am very appreciative of this opportunity to share some information about this newest act that has come out and is affecting so many companies. So this is our agenda today. And as you guys are, I'm sure, very aware, on January the 1st, 2024, there was a new act that was put in place. It's affecting an estimated 32 million businesses that now have to comply with new reporting requirements that are being implemented by the Corporate Transparency Act, or CTA. The CTA mandates that certain information about business owners must be provided to the Department of Treasury's Financial Crimes Enforcement Network, also known as FinCEN, which makes it much easier. And there are some penalties that exist for non-compliance. So all of this builds on the Anti-Money Laundering Act of 2020, which was implemented to crack down on illegal activity like corruption, money laundering, drug trafficking, and other things. And the thought is that sometimes these players that may be involved in some of these organizations were hiding behind the company name or a company. So the CTA was put into place to help with that. So with that in mind, this is our agenda for today. I'm going to start off with talking about a little bit of background information. I think it's necessary for us to understand where this is all coming from. I also realize it's the least engaging part of any presentation, so I'm not going to spend a lot of time on that. But I do want to discuss a little bit about it. And then we're going to talk about who needs to report, what the entities that need to report have to report. What information are they looking for from the different entities and from the reporting company, from the beneficial owners, from the company applicant, if it is something that applies. Then we're going to talk about reporting deadlines. When do these reports need to be filed? There's a difference between if it's an existing entity, one that was formed before January the 1st, 2024, or one that was formed afterwards. So we'll talk about those deadlines a little bit. And then we'll finish up by talking a little bit about the BOSS system, which has been put into place, and some other things that we need to remember as we're working with this particular new act. So as I said, I'm going to start with a little bit of background information. Again, I just think it helps us to know where we started. So when we look at the United States, there are over 2 million corporations and LLCs that are formed annually in the United States. And while we hope most of them are being formed to be productive parts of our society, there are some, sadly, that we know that are not they're not up to any good when they are forming some entity. So up to this point, there has not been a lot of emphasis on gathering information about the people behind these smaller entities. So when you form a corporation with the state, they don't ask a lot of information about the beneficial owners in most situations. So the thought is that this would gather that information and hold it in a secured place. So the CTA has been created to allow law enforcement and national security agencies to gather more information about the individuals so that they can no longer hide behind a company name. We're going to talk more about the beneficial owners and the individuals that are involved as we go through this presentation. But as I mentioned, it is all in an effort to slow down on some of the illegal activity, such as tax fraud, money laundering, and things that might be going on where people are hiding behind a company name. The Corporate Transparency Act was passed, as Sarah said, in 2021. It was part of the Money Laundering Act of 2020. However, time was given to FinCEN to develop regulations. Therefore, the act did not go into effect right away. Additionally, Congress wanted to give businesses the heads up about the new law. And so in September of 2022, FinCEN issued their final rule. This has not been an extremely smooth process. There has been controversy and objection that has faced FinCEN as they have been trying to put some of this in place. There is concerns about the lack of education, the lack of knowledge that's been being sent out to people who could possibly be affected by this act that's going into place. And there are still concerns, as you are well aware, of how this is rolling out and the things that are being required for business entities. Again, the information is to gather business owner information so that the individuals behind the company names. FinCEN has developed a platform of their own, and it's called BOSS, Beneficial Ownership Secured System. It did launch, as I said it would, on January the 1st of 2024. So it is now available, and we'll talk more about it as we go through. We'll talk about the security around it and the limited access to the actual BOSS platform. So let's talk about who needs to report. This is broken down into 3 different areas on my slide. A domestic reporting company. So if you are a company or an entity that is created by filing a document at the Secretary of State or similar office, sometimes they're not always filed at the Secretary of State. If you're working with an Indian tribe or something of that nature, it may be called something different. But if you are filing documents in order to do business, in a particular state, you are going to be considered under the guidelines a domestic reporting company. So any entity that's created in the United States that is filing at the Secretary of State and does not meet one of the 23 exemptions, they would be required to file the beneficial owner report. Likewise, if it is an international company that has filed paperwork and is doing business within the United States, again, they filed it at the Secretary of State or an equivalent office, and they are doing business in the United States, they would be considered a foreign reporting company. And they too would have to, if they don't meet one of the exemptions, they would have to file the business owner report with FinCEN. There is another category that's called other entities. It's kind of a catch-all for the final rule, and it's expected that it will include LLPs, LLLPs, statutory trusts, business trust, and most limited partnerships. FinCEN does not expect this other entities category to include sole proprietorships, general partnerships, or other trust other than statutory and business trust. So those are the three categories they have put out of the companies that need to actually file a report. So let's talk about who does not need to file the report. There are 23 exemptions that FinCEN has put out as companies that do not have to file the beneficial owner report. So if you are in one of these categories, then you don't have to file anything at all. I've gotten several questions. I work generally with large law. I've gotten several questions about, do we have to file something even if we're on the exemption list? The answer is no. If you are one of these exempt entities, you do not have to file that BOI report. Most of these, if you look over the list, and I'm not going to go through each one of them individually, but if you look over the list, you will see that most of these entity types are ones that are already pretty regulated, whether it's regulated through the Security and Exchange Act of 1934, the Investment Act of 1940, Commodity Exchange Act, or maybe even Sarbanes-Oxley Act of 2002. They are already regulated. They are already having to give a lot of information to the government when they are forming their entities. So for that reason, and because of those regulations, these type entities would be excluded from having to do the new beneficial owner report. There are two types that I want to talk about on this list because these are the ones that we as a company have gotten the most questions about. One is number 23, which is an inactive entity, which we would assume would be pretty easy to define. There is a 6-part test that an entity has to be taken through in order to qualify as an inactive entity. So things such as, was it in existence on or before January the 1st of 2020? Is it engaged in any active business? Is it owned by a foreign person, whether directly or indirectly, wholly or partially? Has it experienced any change in ownership in the past 12 months? Or has it received any funds greater than $1,000 in the past 12 months? And does it otherwise hold any type of asset, whether in the United States or abroad? So if you are wondering if an inactive entity actually qualifies, you need to be careful to look at the full definition of an inactive entity that would be outlined for you on the FinCEN website. The other entity type that is causing a lot of questions is number 21, which is the large operating company. So I'm going to spend a few minutes looking at what qualifies as this large operating company. There are 3 things that a company has to have in order for it to be considered large operating company under the guidelines of FinCEN. One is it has to have employees of 20 or more, full-time employees. It has to also have federal income tax of $5 million in gross receipts or sales within the United States. And it has to have an operating presence or a physical office in the United States. This is not an or situation. This is an and situation. So in order to be a large operating company, it has to be A, B, and C. So let's dive into these a little bit more. When we talk about full-time employees, what FinCEN did is they looked at the final, when they did the final rulemaking, they looked at the Internal Revenue Code and their definition of what is considered a full-time employee. So if you have questions about, do I have 20 plus full-time employees? What happens if I have 20 plus at a certain time of the year and then it drops down at other times of the year? What does that mean for me? You would most likely want to seek out advice from a tax attorney who would know this IRS code backwards and forwards and would be able to tell you what it says about a full-time employee in that actual code, the IRS code. Another thing I want to say about the employee headcount is this has to be employees at one specific entity. So if your entity is filed with the Secretary of State or another office, equivalent office, and you're doing business within that state, the entities have to be, or the employees have to be within that entity. You cannot group employees together. So if there's multiple locations, but they're all individual entities, you cannot group them together. It has to be that particular entity has 20 plus employees. The second thing, the gross receipts or sales of 5 million. That is U.S. revenue only, and that can be consolidated with other entities that may be under the same umbrella. So that can be a consolidated amount, whereas the employees are per entity. And then the last thing would be to have an operating presence in the United States. So they have a physical office, which means they regularly conduct business at this physical location, and that the entity either owns it or leases it, and that it is physically distinct from the place of business of any other unaffiliated entity. So you can't share with an unaffiliated company your presence. It has to be something that is unique to that particular entity. Now, it can be a personal residence. So if it is a home address, if that is where they are doing business every day, it can be a home address as well. It can be a personal residence. So let's talk for a few minutes about the reporting requirements. There are three different things or three different reporting areas that FinCEN is looking at. The first one is going to be the reporting company itself. There is nothing that is this unusual about what information they are looking for from the reporting company, and we'll talk about that in just a second. The next is going to be a beneficial owner report. So that information about the beneficial owner, and we'll talk about this in much more detail, you have to supply information on the beneficial owner, and it's every beneficial owner. And the last thing is the company applicant. Now, the one thing I will say about the company applicant, and we'll see this as we go through, this only applies to entities that have been formed January the 1st, 2024 and forward, who do not meet one of the 23 exemptions. So if you have existing entities, those that were formed before January the 1st of 2024, you do not have to have a company applicant. It is only going forward if you do not, if you cannot use one of the exemptions, that you would have to have a company applicant. So let's talk about these a little bit more. For the reporting company, the information that FinCEN is requiring to be reported is of course, the full name, which you would want to get the legal name, probably from the formation documents would be your best source. You want to put any DBA names that they may be using. They would like to see all of those listed. They want a complete current address. And this address is going to be the principal place of business. And so that information would need to be reported as well. You have to put where this entity is formed. If you have filed or formed your company or your entity in the state of Georgia, you have to list out where you have formed it. If it has been at a tribal jurisdiction, you would need to list that out as well. And then if it's a foreign reporting company, you would need to list the state or the equivalent of where the information and where they have first formed to do business in the United States. You also have to include an IRS tax ID number. And if it's a foreign reporting company and they don't have the tax ID number, they can use a foreign ID number, tax ID number. They just have to list where that is from. So what jurisdiction that ID came from. So that is the information that is needed for a reporting company. Now let's talk about the beneficial owner. If you are a beneficial owner, or if you are collecting beneficial owner information, this is what you need to have. You need to have the full legal name of the individual, the date of birth, and you have to have a complete address. And this is going to be their home address. So this is a residence home address that they would need for the beneficial owner. Then FinCEN is also requiring a unique identifying number, and it can be a number that maybe is from an unexpired passport or driver's license, and it could be a state issued ID. And if it's a foreign entity, it could be a passport that's been issued by a individual from a foreign government, which is fine. But there has to be an image, regardless of which one of these you choose. There has to be an image of that document that is also submitted to FinCEN. They want to be able to cross-reference the information that has been put in, the unique identifying number, to the document that it has been taken from. So for a beneficial owner, you have to have this information. Now let's talk for just a minute about a beneficial owner. What is FinCEN talking about when they say a beneficial owner? They have given two categories. One is someone who owns or controls at least 25% of ownership interest in a reporting company. The other is someone who exercises substantial control over a reporting company. And that one casts a fairly wide net. So we will, now FinCEN's stance on this is that there is always going to be one or the other. This is an or situation, whereas when I was talking about large operating company, I was saying it was an and situation. This is an or situation. So they can either own 25% or more, or they can have substantial control. They feel that with every entity that is in existence, there would be someone who has one or the other. So let's talk first about the substantial control. There are, so a reporting company is required to identify all individuals who exercise substantial control over the company. There is no limit to the number of individuals who can be reported as exercising substantial control. An individual is going to exercise substantial control over a company in 4 different general areas. The individual is a senior officer. The individual has authority to appoint or remove certain officers or a majority of directors. The individual is an important decision maker, or the individual has any form of substantial control over the reporting company. So when we look at that in a little bit more detail, we will see that substantial control can take several different forms. It could be substantial control in the business form, or the finances, or the structure. So if it's business, it could be the nature, the scope, or the attributes of the business. It could be the selection or termination of business lines or ventures, or a geographic focus. It could be in talking about the ability to control termination or fulfillment or non-fulfillment of a significant contract. So as I said, this part of the beneficial owner does cast a wide net and can include a lot of people. There is
also, can I make just one point there? Sure. Can we go back to the last slide? So the definition of substantial control in this specific point is obviously extremely broad, and IFA is engaging with FinCEN to get clarification on substantial control as it relates to franchise relationships. given the broad nature of the definition. But if there are other concerns from participants on the call around clarification from FinCEN as to the meaning of the CTA, please send those to me so that we can funnel those through to FinCEN. Thanks, Beverly. Sorry.
Sure, no problem. Yes, I would say that in my conversations, deciding who is the beneficial owners has been, well, deciding whether you're exempt and deciding who is the beneficial owners have been the two largest questions that we have heard about in the months that we have been talking about this with folks who are using CT or who are interested in this topic. Continuing on, and again, as Sarah said, this is broad. It casts a really wide net. So here we see that there's even more information about the beneficial owner, whereas it can go into if you exercise or control directly or indirectly, into a board representation or the majority of the voting rights or voting power. If you have any rights associated with financing arrangements or interest in a company, all of these could also be included as beneficial owners that would need to be reported. And I will say I was on a panel with an individual from FinCEN, and there were a lot of questions that came up about that. So I agree with Sarah that there needs to be more clarity around what exactly they are looking for. One individual actually raised his hand in the audience that day to ask if he evidently formed an LLC to purchase a home. And he said to the individual from FinCEN, "You're not looking for me, right?" And he said, "That's exactly who we're looking for." So he was indicating that it's better, if you have a question about it, it might be better to list them as a beneficial owner than to not list them. All right. So when we talk about the ownership and what the ownership includes, obviously 25% or more. I have had questions about, does FinCEN want to know what percentage? The answer to that at this point is no. There's nowhere on the FinCEN site or any other that I've seen that indicates that you have to put, this is a beneficial owner because they own 25% or more, or 30% or whatever it might be. But if they do own 25% or more, any of the following may be of ownership interest. So equity, stock, or voting rights, a capital or profit interest, convertible instruments, options or other non-binding privileges to buy or sell any of the foregoing, and any other instrument, contract, or other mechanism used to establish ownership. So a reporting company may have multiple types of ownership interest. So you do have to be mindful of that when you are looking at those. And if they do have any stock or they have any ownership, it can take different forms. There are some exceptions to the beneficial owner reporting. If you have a minor child, they are going to be exempt from having to be listed as a beneficial owner. However, they do want the information on any guardian or parent of that minor child to be listed as a beneficial owner. If there are any nominees, custodians, or agents that controlled by someone else, they do not need to be reported, but you will still need to report anyone who might be controlling them. Future inheritors do not need to be listed as a beneficial owner until death occurs, and then they step into a position where they would be considered a beneficial owner. Employees who are not senior officers, the question will be, do they have substantial control? So they may not have a title, but they may fall under the substantial control definition that FinCEN has put out. And then lastly, creditors. And if they are not exercising substantial control, and generally if it is rights that are solely through an interest for payment or a predetermined sum of money like a debt, they are going to be exempt from being listed as a beneficial owner. Let's talk for a minute about a company applicant. As I mentioned earlier, our company applicant is going to have to be listed on the beneficial owner report if you have formed this entity after January the 1st of 2024, and it does not meet one of the 23 exemptions. The company applicant is going to be the person defined by FinCEN who directly files the document to create or register the reporting company, or the individual who is primarily responsible for controlling such filing. So as I mentioned earlier, I work with a lot of law firms. And so oftentimes they are concerned that the attorney, who is obviously giving a lot of information and directing documents and things, may be listed as the company applicant. You will also find that there are some third-party companies, such as mine, who will act as a company applicant in the area of directly filing. So there are questions still around the company applicant and how that will work. But here are some examples. For example, individual A, who wants to create a company, prepares the necessary formation documents and directs individual B to file the documents with the relevant state. Individual A and B are both the company applicants. There is something that FinCEN has put out called the FinCEN identifier, and there have been many people who have already been gathering that or getting that identifier. What that allows is if you are the beneficial owner or if you are the company applicant of multiple entities and you do not want to supply the information I mentioned earlier each time that you're going to be a beneficial owner, you can get a FinCEN identifier. That means that you would go to the FinCEN website. You would fill out the information they're requiring. You would give a copy of the document that they're requesting, one of the documents. And when you submit it, they will then give you a FinCEN identifier. And moving forward, every time you would need to do a report, you would just have to use a FinCEN identifier. So that is something that's available for beneficial owners and company applicants if they so choose to have that. Now, when you get a FinCEN identifier, one thing that I will point out, and I will tell you, this has caused many people to be concerned, and I'm hoping that this will be changed. Currently, if you get the FinCEN identifier, the Act states that FinCEN identifier number stays with you like a Social Security number. So it will be with you for forever. And there are requirements to keep that information associated with the FinCEN identifier up to date. So that is a concern, and hopefully that will be something that will be, even though it's been addressed already, we're hoping that they will revisit that and alter the requirements, maybe able to put a pause on a FinCEN identifier if you're no longer with the company or if you've retired or something of that nature to make sure that you don't have to keep up with keeping it current. Let's talk about the reporting deadlines that have been put in place. If you are an entity that has been created before January the 1st of 2024, the good news is you have until January the 1st of 2025 to get that BOI report submitted into FinCEN. Again, if you were created before January the 1st of 2024, you have a year to get that input. If you are creating an entity after January the 1st of 2024, and again, we're assuming that these entities do not meet one of the 23 exemptions, you have 90 calendar days to get that report submitted into FinCEN. And it says the date received actual notice of creation or the date the Secretary of State first provides public notice of creation. So you have 90-day window to get those in. Now, bear in mind that this is just for January 1st, 2024. When January 1st, 2025 rolls around and it's a new entity, they are indicating they're going to go to a 30-day turnaround for the BOI report. So it's currently 90 days. All of it was 30 days until just a few months ago when they decided to give those created after January 1st, 2024, 90 days. But they do want to make it clear that January the 1st, 2025, it goes back to 30 days. That's a long way away. So there may be some changes between now and then, but that is what they are currently stating. And then if you are exempt, but you're no longer exempt, you have 30 calendar days after you are no longer exempt to get that information submitted. Now, when you look at this report, it is filed one time. At least the initial report is filed one time. The problem or the situation comes into play, however, that if anything changes, whether it is reporting company information or it's beneficial ownership or beneficial owner information, you have 30 calendar days to file the changes with FinCEN. So if you need to do a change report or amend something in some way, let's say you have a beneficial owner whose passport expires. You have to get a new passport in place. You have 30 days in order to do that. I have no idea how this is going to be policed, but that is what they are indicating. So if an address changes, if a passport or driver's license expires, anything of that nature, you have 30 days to get that information in. If you have filed a report and you have made an error, you can go in and do what they are calling a correction report. And that needs to also be done within 30 days of the notice that it has changed. So you have 30 days for corrections and you have 30 days for updates. Let's talk a little bit about some additional considerations that we need to talk about or we need to address. One is the BOSS network that I mentioned earlier. And this is a site that FinCEN has created, and they have built a very secure site to store, to receive, to store, and to maintain the BOI information. So it's at the highest level of security. It is a cloud-based system. You would get onto their platform or their website, and you can go in and fill out all of the information and submit it to the BOSS system. And it would go into a secure database. There are also other companies that have created platforms that you can use, which give you a little bit, well, not a little bit, a lot more flexibility than you would have if you were going into the FinCEN site. So they do allow for third-party service companies to actually help you file the document by using their platform or their portal, and you go in, put in the information that's required. Companies such as mine, if you do that, it goes straight into the BOSS platform. It does give you a lot more flexibility where you will be able to view that document again. And we'll talk in just a second about who gets to view the BOSS network. It's very limited. But you get to view that information again. You get to go in and make changes. If you need to amend or correct anything, you can do that. So there are some third company providers out there that you should be aware of. BOSS is a free service that allows you to go and fill it out, but it is limited in what it allows you to do once you have put in the document. So let's talk about that for just a minute. Because of the secure nature around this information, BOSS is very limited to who can have access. So if you are with federal agencies or you're with state and local government, you can have access if you have a very specific reason or you petition the courts to allow you to have access. They have very much locked it down. If a state or local government or law enforcement can say and prove that they are working on a criminal or civil investigation and they can get authority to actually look at it, they would be able to look at it. Foreign law enforcement, again, with permission from the courts, and they would have to give specific circumstances and reasons, they would be able to see it. Financial institutions, and there's going to be a few changes to some of these coming down, but this is what they have right now. But the financial institutions, if they have the consent of their client that they're working with, and if they can prove that it is in conjunction with getting their customer due diligence complete, financial institutions can have access. Federal regulators can also have access if they can, again, verify that they are working on some kind of suspicious activity that they have been monitoring, and therefore they're going to have need to get into that platform. They will be able to get access. Again, most of these are through petitioning the court in order to get into it. And then, of course, the U.S. Department of Treasury. So all of that to say that most people will not have access to this platform. So once you hit submit a filing, it's going to be submitted and you will not be able to go back in and make changes to it. You would have to start again on the BOSS platform in order to complete that particular filing. There is a certification that's required. Basically, it's going to state that the person who is hitting that submit button is saying that to best of their knowledge, this information is true, it's correct, and it's complete. And it's definitely one thing that's on the FinCEN website that has caused some people to pause. I think that there are a lot of words surrounding it. So you do want to make sure that you read that. They do say that they understand that there could be some errors that are caused accidentally, and they understand that. But they're looking for those who are willfully supplying false information or fraudulent information. There are penalties that are associated with noncompliance, and those penalties can be anywhere from a fine of not more than $10,000 to jail time. It is a criminal offense if they find that you are fraudulently or willfully withholding information. So they can enforce a jail time. Sometimes it could be both. And you'll see that there's also civil penalties that can apply as well. So all of that information into, I think, 35 minutes. And I want to thank you all for attending. And certainly I can go to the next screen. If someone will let me know if you're ready for me to go to the next screen where they can enter in information. Are there any questions that I could answer? Anyone?
Yeah, Beverly, I've got some questions. Can you go to the fan screen with the QR code? Because we kind of went past it quickly at the beginning, just so that
at the beginning, not this one right here, not the one I'm showing.
It's the same one. That's fine. So just so that the people can get connected for any additional updates on CTA. And then just looking in the chat for the I'm going to do the questions that are kind of general questions, not specific questions as to individual facts. So one, what do you do when you're no longer a beneficial owner? How do you remove your information from BOSS?
That's a good question. If you are a beneficial owner and you've associated yourself with a company at this time, my understanding is it would be difficult to not be associated with that company. You could go in. I have not heard of anyone having the situation at this time. It may be something that we would have to look at as we get further into it. I don't know that there's been an issue where someone's tried to remove themselves as beneficial owner. And so, Sarah, I don't know if you have other information on that or not, but I, at this time, would be hard pressed to give a full out answer to that question.
Okay, and I don't know either. We can certainly seek clarification there.
So much of it is so new. it's going to
Uh,
just take time.
Yeah, and that's just for clarification on that point also, that is a large reason for the bill that's pending is that that FinCEN has issued guidelines literally like in the weeks before the compliance requirements became effective, trying to provide guidance on implementation of this, but it's still very unclear, which is why the bill is seeking for an extension of another year so that FinCEN can figure out how this actually works in practice. Beverly, you may have touched on this, but how do you secure a FinCEN identifier?
You go to the FinCEN website, and there will be a place where you can enter in your information that's required, the documentation that's needed, all of your personal information, and you submit it one time through the FinCEN website, and then they will contact you with the FinCEN identifier. For of course, the people at my company have gotten that, and I've understood that the process is fairly smooth. So if you do feel that that's something that you want to get, I would just encourage you to go to the FinCEN website.
Okay, I'm looking through the questions. Do exemptions have to be filed, or do you just do nothing if
You,
you're exempt?
yeah, if you are exempt, you don't have to do anything. If you meet one of the exemptions, one of the 23 exemptions, then the FinCEN's view is you are already in an industry or an area that they are gathering enough information on you, so you do not have to file or fill out the beneficial owner report.
Okay, on the large company exemption, that and this is my understanding, but do correct me if I'm inaccurate. The exemption applies only to the company that meets the exemption criteria. It does not flow down to all of its affiliated and subsidiary entities, correct?
Correct.
Okay.
Remember, the key thing to remember too is if you have an entity that you have filed documentation with at the state, or whether it's foreign or domestic, that falls into the category of having to do the beneficial owner.
How will compliance be monitored and enforced since this is all self-report? That's a very good question that I think a lot of people that were concerned about
Yes.
implementation of CTA voiced. It's really unclear how this will be enforced.
Very unclear how they will police and enforce it. Their platform wasn't even ready to go until the day it was started, basically. And so you wonder how much manpower they're going to have to actually review and police all of this information that's being sent to them. I will say it's interesting that a couple of states have decided that they're going to be collecting more information on beneficial owners. New York is one that is saying in 2025 they're going to be requiring more information. Massachusetts is one that is moving towards that. Pennsylvania has already been gathering some of that information, as has Washington, D.C. So we may see more states that are requiring more information about beneficial owners as well.
Right, and I think that was that was some of the concerns that that IFA and others voiced prior to CTA passing in 2021, was that a lot of this information is already provided to the states, and that this is just an additional layer. And really that's not necessarily supported or is unclear how it's going to be used.
Right.
There's a question regarding what the government will do with the names they gather, and what rights you have when issues or mistakes are made. And I'm not clear on what the process will be when there's a mistake, but certainly the questions that we're unable to answer, I'm adding to a list for us to seek clarification. from FinCEN on those questions. So Beverly, if you can answer that, please do, but otherwise we'll see.
I don't have an answer for that. As I said, this is so new. I have no clue how they're going to handle all of this, or even, how the process may change moving forward. I hope that they will revisit a lot of the information and, maybe tone some of it down, or give some more clear guidance on some of the things that they're asking for. But in my line of work, we depend a lot on case law, and we don't have anything to fall back on at this point. So I'm hard pressed to tell you how any of this might actually play out, or what may happen, or how they will even find someone who has fraudulently entered information.
And then there was another question. So the large operating company exemption, it's more than 20 full-time employees.
20 plus employees. Mm-hmm.
I think the exemption is more than 20. Yes. So 20 would not work. It would have to be more than 20.
Mm-hmm.
Just rolling through any additional questions that we can answer. If an exemption applies for if an inheritor is exempt, if an inheritor exercises substantial control, are they still exempt as an inheritor?
They are only exempt until they inherit. It's future inheritors that are exempt as a beneficial owner. If they're at the time of death of whoever they are inheriting from, when that occurs and they become an inheritor, then they would not be exempt.
Okay. I think we have answered. I don't know if you can answer this. I certainly can't. Any responsibilities? Are there any responsibilities for enforcement being delegated to the IRS, or other agencies? And do we expect cross-referencing in audits?
I have gotten that question a lot. There's been a lot of concern from law firms about how sometimes when they do formations, they sign as the incorporator. Of course, that all goes to the Secretary of State, and I have not heard any plans to cross-reference that information. So I would have to say at this point, other than the IRS, them using that as the way to determine the number of full-time employees, I don't know that there's going to be anything else going on with that. Oh, and the gross 5 million, which is something that the company would have to supply, showing that. And that would be a tax return that would show that gross amount.
I think we have covered them all, although honestly, there's a lot of questions. So it's possible we haven't. And I will reply to you separately if I did not get to your question on the presentation. But again, for those that join late, the presentation will be available for on-demand view at community.franchise.org. If you have difficulty locating it, feel free to contact me. My email address is sdavies, DAVIES @franchise.org. Beverly, do we have a slide for you at the end? Didn't we have a slide for your information?
Mm-hmm.
Okay. And then wasn't there a QR code also for Wolters Kluwer's there? Okay, perfect. Oh, so this is the code for your resources. Can we go to the FAN slide? Because that's the one I was wanting to go on earlier.
Right here.
Yeah, perfect.
Okay.
Wonderful. Well, thank you all for joining us. Appreciate
Yes.
it. And do send questions through to me for clarification from FinCEN. We will be looking to gather that later this week, early next week.
All right. Thank you, everyone.
Thank you. Bye.